For today's story, we talk about the Charlottesville rally, which has resulted in a $31.8 million civil verdict against various organizations that helped to put the rally together. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal educational content, and today may be the day I earn your subscription. For today's story, we are talking about the aftermath of the Charlottesville rally. This is a rally that occurred in Charlottesville, the famous Tiki Torch rally, where a woman died after being hit with a car. And some of the organizers involved behind that have been sued. And today, a judgment has been entered against them for $31.8 million in various damages. So we're going to read this article and we're going to read the judgment from the jury. So let's go ahead and get started with this. So there is a picture of the infamous rally, the Tiki Torches, which is one of the lamest rallies ever, just from the Tiki Torches alone. And the jury has returned this $31.8 million verdict against various defendants in this action. A federal jury has returned this $32 million verdict in a case connected to Unite the Right. In August 2017, a collection of 9 plaintiffs sued a number of figures, including Jason Kelsler, Matthew Himbach, Richard Spencer, and Christopher Cantwell, on a series of both federal and state claims. The jury did lock on some of the claims, but returned verdicts on other claims in various dollar amounts. So the jury wasn't able to reach a verdict on all the claims, so the judge let them come back with a partial verdict. So, whatever they come back with is fine. They couldn't reach a verdict on some of the counts. So, they can have another trial over that, which is unlikely, but they could. According to the instructions presented to the jury, the plaintiffs alleged a series of state and federal crimes: conspiracy to commit racially motivated violence in violation of 42 U.S.C. 1985, failure to prevent that conspiracy in violation of 1986, civil conspiracy under state law, engaging in racist, religious, or ethnic harassment under state law, assault and battery, and intentional infliction of emotional distress. Not all the plaintiffs alleged all the counts against all the defendants, so there's a mix of what charges are being made by what people, what counts are being made by what people. The jury deadlocked on some of the counts. It agreed the plaintiffs proved the 3rd, 4th, 5th, and 6th claims, but assigned no dollar amount in damages on one portion of the claim to James Field, who plowed the car through Charlottesville. So they found him responsible civilly, but they didn't award any damages against them. And then it's noted here that Fields was convicted and sentenced criminally to life in prison plus 419 years, so probably doesn't have a lot of ability to pay. But yeah, they found him liable for that and assessed no damages against him because, he has no money. So, fair. 4 of the plaintiffs were injured in the car attack that was perpetrated by Fields. There were physical injuries, including concussions and skull fractures, and they suffered from post-traumatic stress, including insomnia, the ability to concentrate, flashbacks, and panic attacks. Significant chunks of the jury award were earmarked as compensation. Those are damages designed to compensate the plaintiffs for actual losses. However, the most significant awards were tailored as punitive damages. Those are amounts designed to punish the defendants for conduct the jury believed was worthy of monetary sanction. Several of the defendants immediately moved to reduce punitive damages award pursuant to Virginia law. Virginia law caps total punitive damages at $350,000. The punitive damages are thus poised to be reduced considerably by the court, regardless of the dollar amounts wrote on the form. So yes, many states have put in place tort reform. And one of the things that tort reform does is puts a cap on punitive damages and says you can't recover more than this much in punitive damages. You can recover as much as you need in compensation. So in terms of what your actual loss is, there's no limit to your ability to recover. But in terms of punitive damages to merely punish the conduct, $350,000 is a cap. So the jury awarded all these millions and millions of dollars. But as for anything that is reliant on a state level charge, all those damages would have to be reduced. And also, we're going to get into some of the other reasons that some of the other amounts will be reduced. So we'll talk about a little bit more when we get to the jury form, which amounts will be reduced, and we'll talk a little bit about by how much. Okay, so we are going to look at some of the claims that the juries came back with. So first of all, we have a Virginia-specific claim for civil conspiracy against all those people. So that would be a situation where punitive damages would be limited. As we see, all the defendants were found liable for all those things. And there's a whole bunch of people there listed, as you can see and read for yourself. As for actual damages, the jury didn't really find any actual damages. So they found only nominal damages, except against Elizabeth Sines and Chelsea Avardo, where they didn't even, or Seth Wilsby, where they didn't even award nominal damages. So $1 is the typical amount of nominal damages. That's usually what we mean by nominal damages. It's like, yes, you were hurt, but you didn't really, yes, your rights were violated, but you weren't really hurt. So you win, but we give you $1. And so that's kind of what the jury seemed to do here for actual damages as to the civil conspiracy. And that's what they thought was the actual damage. And then we get into the punitive damages, which, as we can see, is quite a bit higher and goes quite a bit higher. We're talking $500,000 awards and $1 million awards for various people. Now, as we pointed out, Virginia has a cap of $350,000. Also, there's another problem. There is a U.S. Supreme Court case that seems to very strongly suggest that punitive damages can't go above a certain multiplier of actual damages because of actual due process. This is a case called that came out of State Farm from the U.S. Supreme Court way back in the day. And so these damages are, they're 500,000 times or 1 million times actual damages. So this case from State Farm might suggest the jury maybe these amounts get reduced to like $10 because you can't go above certain multipliers, and they didn't award any actual damages. So it may be the case these guys have to pay basically nothing because of the way the jury found these assignments. They didn't find any actual damages. So the punitive damages can only be so punitive. So, maybe all those amounts get reduced to basically nothing. Okay, now we have a fourth claim. This is again under Virginia specific code, so Virginia law is going to apply as to the damages here. Now we find some actual damages against Natalie Romero and Devin Willis, $250,000 apiece, so that should be no problem. So this is joint and several liability. So these aren't the defendants here in the middle, Natalie and Devin. Those are the plaintiffs. So these are amounts that will compensate them, $250,000 apiece. And then we have some punitive damages on top of that. But again, Virginia law applies, $350,000 cap, and plus there's the multiplier problem. But that doesn't seem to be an issue here. So they should be able to get about $750,000 out of that claim. Fifth claim for assault and battery. This is going to be state law again, because those are common law torts. Again, we come up with some exact dollar figures. I'm not sure how we're coming up with these dollar figures exactly. One would assume that there was some testimony about particular medical losses or other things, because some of these numbers are very exact. So Natalie has to pay $217,715. Elizabeth has to pay $0 for something. And yeah, again, we have this cap because we say $6 million, but there's a cap of $350,000, as we mentioned, because these are all state law claims, so that amount is going to get dramatically reduced as well. Sixth claim, intentional infliction of emotional distress, also a state claim. Again, we come up with some fairly specific numbers. $155,715 for one of them, $246,757 for another, $98,987 for yet another, and then $6 million of damages. But again, state law, so that will massively drop. So my friends, the Charlottesville rally has come to a civil judgment. The jury has awarded $32 million, but Virginia law caps punitive damages. And there's problems with the amount of damages relative to the actual losses in some of these charges. So I would imagine that this $32 million damages is going to get reduced dramatically. How dramatically, I don't know, but it's probably going to not be more than a few $1 million, like $2 or $3 million by the time we're done, if even that. But those are issues for law for another day. So as this case proceeds, we'll keep on. But for the moment, at least, that leads us to the end of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.